हेलो फ्रेंड्स, गुड मॉर्निंग एंड वेलकम टू आवर टेक्साज ऑफिशियल यूट्यूब चैनल, जहाँ पे नई नई तरह की वीडियोस लाते रहते हैं अबाउट लीगल टैक्सेशन एंड फाइनेंशियल मैटर्स। तो ये सीरीज़ चल रहा है लीगल स्टडीज़ का, और आज हम सीपीसी के एक नए टॉपिक पे आ गए हैं। यस, दिस इज़ सीपीसीज टॉपिक, सिविल प्रोसीजर कोड का फंडामेंटल रूल्स ऑफ प्लीडिंग। तो ये फंडामेंटल रूल्स ऑफ प्लीडिंग जो है, ये एक ब्रॉडर कॉन्सेप्ट है। इसके अंदर हमने 3 अलग अलग वीडियोस बना के रखी, आपको सीरीज वाइज मिल जाएगा यहाँ पे हमारे चैनल पे, इसी प्लेलिस्ट में। तो चलते हैं। दिस पर्टिकुलर टॉपिक इज अबाउट व्हाट आर द फंडामेंटल रूल्स ऑफ प्लीडिंग, डिस्कस देम इन डिटेल। क्वेश्चन आंसर पॉइंट ऑफ व्यू से ये मैंने प्रेजेंटेशन बनाई है, जहाँ पे it will help you to extract maximum marks in examination if you write with this format. Fundamental rules of pleading. According to Order 6, Rule 2 of CPC, fundamental rules of pleading are as follows. Every pleading must state the facts and not the law. Analysis of the rule shows that it has two parts, one affirmative and the other negative. The affirmative part of the rule directs that pleading must state facts, while the negative part states that a pleading must not state law. एक affirmative है, एक negative है. It is well settled rule that in pleading only facts have to be stated and not the law. Now the question in consideration arises to as what is the implication of saying that pleading must not state law? The implication is that the following things should not be stated in a pleading: provisions of law, conclusion of law, conclusion of mixed law and facts. It has been held that to see as to whether a fact has been pleaded by the plaintiff, the court is not to confine its gaze to the plaint, it has to extend to the replication also. It is to be noted that a pleading is not required to state law for the obvious reason that the court are bound to take judicial notice of the law applicable to the facts pleaded by the parties. Thus, if in a particular case the court finds suo motu that the rules under which the DIG police proceeded to dismiss the plaintiff were ultra vires, means out of the scope, and so inoperative, it is its duty to declare that the order of dismissal was illegal. It has been held over and again that it is for the court to apply the legal principle in the light of the facts pleaded by the party and established by him in evidence. Again, it is to be noted that the above rule applies not only to the pleadings of the plaintiff but also to those of the defendant. एक एग्जाम्पल देख लेते हैं. Where the Union of India in its written statement denied the service of the notice under section 80 CPC but did not plead that the suit was premature and therefore not maintainable. It was held that the averments in the plaint itself established beyond doubt that the institution of the suit was premature. It was not necessary for the defendant to recapitulate those facts and the consequences therefrom. एक्सेप्शंस क्या क्या हैं इसके, आइए इस पे बात करते हैं. द रूल दैट एवरी प्लीडिंग मस्ट स्टेट फैक्ट्स एंड लॉट्स इज सब्जेक्ट टू फॉलोइंग एक्सेप्शंस. Exception 1, foreign law. A court is not bound to take judicial notice of foreign law, therefore they should be pleaded like any other fact if a party wish to rely on them. मतलब हमारे यहाँ के जुडिशियल ऑफिसर्स और कोर्ट्स यहाँ के लॉज से अवगत हैं, बाहर के लॉज से तो अवगत नहीं है. तो अगर ऐसा कोई बाहर का लॉ एग्जिस्ट करता है तो उसे भी एज अ फैक्ट ही प्लीड करना पड़ेगा. ठीक है, तो ये पहला एक्सेप्शन हुआ. दूसरा एक्सेप्शन है कस्टम. द कोर्ट इज ऑल्सो नॉट बाउंड टू टेक जुडिशियल नोटिस ऑफ कस्टम्स और यूजेस ऑफ ट्रेड एंड देयरफॉर दे टू मस्ट बी प्लीडेड लाइक एनी अदर फैक्ट. कोई अगर कस्टम आ रहा है फ्रॉम द टाइम मेमोरियल और वो वैलिडेट करता है, उसे मानना पड़ता है, तो उसको भी एज अ फैक्ट ही हम प्रूव करेंगे, नॉट एज अ लॉ, क्योंकि वो सबके लिए जानना ज़रूरी नहीं है. थर्ड पॉइंट, मिक्स्ड क्वेश्चन ऑफ फैक्ट एंड लॉ. Mixed question of law and fact must be stated in the pleading and they cannot be allowed to be raised subsequently. Easy था, ये तो आप समझ गए होंगे. Fourth point, Legal pleas. The rule against stating law in pleading does not exclude legal paths to a suit or pleas denying the legal rights claimed by the opposite party. Fifth point, inferences of law. Although according to the strict rule of pleading contained under Section 6, Rule 7 of CPC, the inference of law should not be stated in the plaint or written statement. Yet a departure from this rule shall be condoned both in England and India, where the object is to throw light upon the facts so as to make them more intelligible and understandable. Thus, where in a case relating to a gift governed by the Transfer of Property Act, the defendant states in his written statement that the gift was not acceptable by the donee before his death and is therefore void, it would be permissible even though it is against strict rule of pleadings. Second point देखते हैं. Every pleading must state all the material facts and material facts only. यहाँ पे दो वर्ड है, material facts and material facts only. इन दोनों में there is a very thin line difference. Every pleading must state material facts. मतलब जो material fact नहीं है वो प्लीड करना मना है. और दूसरा material facts only, मतलब आपको सिर्फ material facts ही देने हैं, क्योंकि अगर उसके अलावा अगर आप बाकी एड ऑन इंफॉर्मेशन देंगे तो दैट विल जेपरडाइज द सिचुएशन. इतने सारे यूजलेस इंफॉर्मेशन के साथ उसका कोई मकसद नहीं बनेगा. इसीलिए पॉइंट 1, every pleading must state material facts only. The first rule had directed that a pleading must contain facts, but then the statement of all facts having a bearing on the case is bound to overburden the pleading with many unnecessary details. Therefore, the second rule emphasizes that every pleading must state material facts only. The first question that arises in this regard is, what facts are material fact? ये तो ठीक है, हमने मान लिया कि भाई सिर्फ material facts बोलना है, लेकिन material facts है क्या, ये तो हमें पता चले. The answer given by the court is that the material facts are those facts which a plaintiff must allege in order to show a right to sue, or a defendant must allege in order to constitute his defense. अब देख लेते हैं इसका टेस्ट फॉर डिटरमाइनिंग मटेरियल फैक्ट्स कि भाई मटेरियल फैक्ट्स है या नहीं है, उसका टेस्ट क्या होता है. The question as to whether a particular fact is a material or not depends upon the specific circumstances of each case. For example, in a suit for libel, it is material for the plaintiff to set out verbatim in his plaint so much of the document in order as contained in the alleged libel. Libel मतलब आपको पता ही होगा, defamation का एक smaller degree. In a suit for an injunction, it is material for the plaintiff to state that the defendant threatens and intends to repeat that illegal act complained of. Third point, in a suit for negligence brought by a servant against his master from injuries resulting from the unsafe state of the premises, the plaintiff must show not only that the master knew, but also that the servant did not know that the premises were in dangerous condition. Every pleading must state all the material facts. The Supreme Court has laid down in S.N. Balakrishnan versus George Fernandez AR in 1969 that the omission of the single material fact leads to an incomplete cause of action and the statement of claim becomes bad. In other words, the non-mentioned material facts amounts to no pleading, and therefore no cause of action arises. It is well settled rule that if a party omits to plead some material fact, he will not be allowed to give evidence of that fact at the trial. It is equally well settled that if by inadvertence some evidence has been led in respect of such a fact, it cannot be looked into. Thus, where in a suit on promissory note payable at specified date, the plaint contains no allegation of presentment, the plaint cannot be given an opportunity of proving presentment, क्योंकि ये तो obvious सी बात है. This illustrates the first proposition that a party should not be allowed to lead evidence or material fact if it was not stated in the pleading. The second proposition, that if by inadvertence some evidence has been led regarding such a fact, it cannot be looked into by the court, is well illustrated in a Calcutta High Court decision in S. Chatterjee versus Nilima Chatterjee AR 1970, Calcutta. This was a suit for divorce on the ground of adultery. In the plaint, it was categorically stated that one Mr. B discovered the plaintiff's wife and one Mr. N in a room bolted from inside. But in evidence, it was shown that B opened the door of the room locked from outside. यहाँ inside, यहाँ outside. So this is contravention. So B opened the door of the room locked from outside, and discovered the plaintiff in the light of the circumstances of the case, but it was not stated at all in his pleading. The court refused to give any weight to a fact which was not raised in the pleading and held it to be a cooked story. Every pleading must state only those facts which are material and present stage of the action. The last aspect of the second fundamental rule of pleading directs that the pleading should only state facts that are material at the present state of the action without reference to the possible objection of the opposite party. It is not necessary to anticipate the answer of the adversary, which, according to Hale, CJ, Chief Justice Hale, is like leaking before one comes to the stile. इसके exceptions देख लेते हैं. The second fundamental rule of pleading that every pleading must state all the material facts and material facts only, subject to the following exceptions. Exception 1. Condition precedent. There is no need for a party to state in his pleading the performance of any condition precedent for its avertment shall be implied in his pleading. But if the other party desires to contest the performance or occurrence of such condition, he must raise the point specifically and distinctly in his pleading. For example, Mr. X agrees to build a house for Mr. Y at certain rates. A condition of the contract is that the payment should only be made upon the certificate of Mr. Y's architect that so much is due. Mr. Y's architect that so much is due. पेमेंट तभी मिलेगा जब मिस्टर वाई का आर्किटेक्ट बताएगा कि कितना ड्यू है. उसका सर्टिफिकेट मैंडेटरी है. इफ मिस्टर एक्स डिजायर्स टू फाइल अ सूट फॉर मनी अगेंस्ट मिस्टर वाई, the obtaining and presenting of the certificate from Y's architect is a condition precedent to Mr. X's right of action. Here it is not necessary for Mr. Y to state in his plaint that he has obtained the said certificate. He can draft a plaint showing a good prima facie right to the agreed amount without mentioning any certificate. It will be for Y to plead that the architect has never certified that the amount is due. Presumption of law. Order 6, Rule 30. Provides that neither party need any pleading allege any matter of fact which the law presumes in his favor or as to which the burden of proof lies upon the other party unless the same has first been specifically denied. Example, consideration for a bill of exchange where the plaintiff has only on the bill and not for the consideration as substantive ground of claim. Point 3. Matters of inducement. It is sometimes desirable to commence a plaint with some introductory avertments stating that the parties are, what business they carry on, how they relate, are or dispute connected, and other surrounding circumstances leading to the such fact are not essential to the cause of action and therefore not material. These are called matters of inducement and are allowed in England since they explain what follows. On the same basis, they may be tolerated in our country also. यहाँ पे एक चीज़ देखिए, the word used is tolerated. Such prefatory statement should be reduced to a minimum. Point 3. Every pleading must state the facts on which the party pleading relies and not the evidences by which they are to be proved. The rule directs that every pleading shall contain a statement of the material fact on which the party pleading relies for his claim or defense, but not the evidence by which they are to be proved. It was pointed out in Williams versus Wilcox, AIR 1838. A party need not set out the evidence whereby he proposes to prove the facts laid upon him, thou as observed by Cotton LJ in Phillips versus Phillips, AIR 1878. That it is absolutely essential that the pleading, not to be embarrassing to the opposite party, should state those facts which will put him on his guard and tell him what he will have to meet when the case comes on for trial. The view taken in these two English cases has been approved of by the courts in our country in a number of cases, and it has been held that a pleading should state only the material facts and not the evidence proving for them. So this was all in today's video. I hope you liked the video. अगर आपको ये वीडियो पसंद आया है तो हमारे चैनल को लाइक करें, सब्सक्राइब करें और इस वीडियो को ज़्यादा से ज़्यादा शेयर करें अपने फ्रेंड्स, फैमिली और जो भी आपको लगता है जिनके लिए बेनिफिशियल होगा. इफ़ यू नीड द नोट्स ऑफ दिस वीडियो, you just have to write in the comment box your name, your college name and your email address. मिलते हैं आपसे अगले वीडियो में, तब तक के लिए बाय, टेक केयर।